We'll continue this morning with the next case set for our oral argument, which is case number 18CA011328, State of Ohio versus Anthony Parsons. Both parties are represented by counsel. Each of you will have 15 minutes to present your argument. Appellant, of course, may reserve up to 5 minutes for rebuttal. I'll keep track of the time, so let me know if you're going to reserve time for rebuttal. If there are children or victims, please use initials and refrain from using the names of children and victims. Both of you know that the oral arguments are being recorded, so we use the front podium, and we ask that you stay at the podium and keep your voice up. All right, having said that, the court has read the briefs, and we are prepared to proceed if you are. Counsel?
Thank you. And may it please the court state, Mr. Parsons is a 3 assignment of error appeal from a trial court. It was from the trial court. It was a jury trial, essentially aggravated burglary with a repeat violent offender specification. Factually, it's a goofy case. So essentially, the victim in this case, he lives in an apartment in Elyria. He looks out his window, he sees people walking by multiple times. Gets suspicious of this, there's a knock on the door. Starts with 2 individuals, and there's 3 individuals. Door gets kicked in. The victim, when he saw people walking around and knocking, gets out a Bowie knife or hunting knife. Guys come in, and there's a exchange between the 2, but essentially, one of the co-defendants is like, they're looking for a Jose, and the victim's like, I'm not Jose, you got the wrong house, and then they basically start bantering, talking, and one of the co-defendants says, oh great, good thing you're not Jose, you would get stabbed. Basically the police aren't called, just the 3 individuals leave. It's actually the following day where the individuals plus another person are kind of walking around in the area. And a neighbor of the victim calls alerted the police. And that's how this case kind of, the catalyst for this case.
That was so confusing to me. The neighbor called the police.
The victim was, I might have to read between the lines, but my guess is the victim didn't want to be involved with it.
Oh, I understood that
So-
part, but what caused the neighbor to call the police, just because they were walking around?
Not in my backyard, because the neighbor had talked to the victim. They discussed what happened the day before, and I think it was kind of like, no, this is ridiculous. So the neighbor calls in the police asking to come, that there was a burglary. And I'm trying to think of a better way, but it kind of like, not in my backyard. But that's how the police come, they get involved. Victim comes to the station, discusses what happens. At that point, one of the co-defendants comes in to the police station, Mr. Tackett, and makes a statement to the police. A little bit more investigation. Police find out that this was motivated by another uncharged, unindicted person. It was Elijah Nixon. Allegedly, the person Jose that they thought lived in this apartment owed Elijah's money. So they were going to collect money from this Jose. The 3 assignments of error, there's 2 that kind of go off one another. That's a manifest weight and sufficiency. And I also did a hearsay. So kind of 2 divergent areas. Essentially, on the hearsay, that kind of harkens back to another argument I did a few weeks ago where we were talking about Stacey Blevins and Stacey Ribs. In this case, there were statements made that were elicited that talking about basically the co-defendant Tackett, who did not testify at the trial. This is a three-witness trial. This is the victim.
Tackett's the one who came to the police station and said, I want to clear my name.
Yes, correct.
Okay.
So Tackett makes a statement, and on the record, basically how it's elicited is, yeah, Tackett came down to the statement, I want to clear my name, the officer testifies that essentially, yeah, pretty much for the gist of it, what the victim told us was what happened, and that's what Tackett stated. This was that 3 witness where there was the victim and 2 police officers, so Tackett was never testified. And then there was also information about the basis of it. So I talked about how police learned that this Elijah Nixon, his mom owed money. That all came into the record too. And that's where I made my objection based on the hearsay. So I guess you should say there's a difference between the officer, what I'm arguing is there's a difference between officer conduct testimony and substantive material that came from a witness that isn't being presented, that is now coming through as explaining the course of conduct. In this case, by filtering Mr. Tackett through the officer, and there was objections to statements that Tackett made.
I think the state says the objections were not on the grounds of hearsay. Does that create an issue for you?
Well, this is another, I believe this is harkening to another argument we had about a month ago where this trial court's not letting them put a basis. So they're not, it's either sustained or overruled. Okay, so there's no grounds being given. So it's sustained, move on. So objection. And that's kind of, when you're dealing with this issue, I mean, it's hard because you're trying to read between the lines, and obviously on appellate level, all of us.
So it just made an objection and did not state the reason?
Correct. So it's just an objection. And I think I actually put the colloquy between the court and the attorney, the defense attorney, in the brief, where objection, Your Honor, purpose overruled, legal conclusion overruled, and so you're not allowed, you're not being permitted to give grounds, but if you do criminal defense work, I mean, anytime hearsay is a number, well, it is a prosecutor too. I mean, if you have a witness get on the stand and said, and so-and-so said, I mean, I can read through the lines of the transcript and say, as soon as somebody said objection, I mean, it's not hard to surmise that it's normally a hearsay objection. But in this case, where that comes down to is that when Mr. Tackett's basically admission to the police is filtered through the officer, I mean, he wasn't subject to cross-examination.
This may seem a little off on a tangent, but I couldn't help but wonder when I read both briefs, was Mr. Tackett involved as a co-defendant in any of this?
Yeah, he was one of the individuals. So there was 3 men involved. So it was
He was charged.
Tackett.
He was actually,
Yes, he was, and he
at the
took
time
a
of
plea
your,
deal.
and that plea deal was done at the time of your client's
Correct.
trial.
Same
Okay.
thing with Mr. Worthy.
Thank you.
So, and, yeah, Mr. Worthy and Tackett, they were pled, they were done. The second and third assignments of error, which go on to sufficiency and manifest weight, essentially, it's a very specific argument. So you have that last element of aggravated burglary, which is inflicting, attempting, or threatening to inflict physical harm. It's a technical argument, but I mean, and it's the difference between a felony in the first degree and a felony in the second degree. So essentially, these guys kick down the door. They start talking to the victim here. He says, I'm not Jose, I'm not Jose. So there's no testimony actually saying that physical harm was inflicted. Nobody said that these guys swung a knife to attempt a physical harm. So it kind of comes down to did he threaten physical harm? And if you read through the operative facts, there wasn't any threat to inflict. So basically this guy goes, hey, we're looking for Jose. I'm not Jose, you got the wrong house. There was no actual operative words that were threat. So they say there was no operative words that this was actually a threat was made. Now, when I say this is a limited argument, I mean, this isn't saying that they didn't establish the base elements for burglary. Of course, if they went into the house to hustle a guy with money to find this Jose, then you can make the argument that that's burglary. But aggravated burglary, it's either inflict, attempt to inflict, or threaten to inflict physical harm. So nowhere does the victim actually say, yeah, they showed a knife at me, I felt threat. I mean, they busted in the house.
Was not, but the knife was visible when they busted in the house.
There's no testimony that it was actually visible.
No testimony?
The only knife that we have from the testimony is actually the victim kind of geared up when he saw the guys banging on the door. The victim got a hunting knife. I mean, there's nothing wrong with it. Not trying to pass judgment on that, that regard.
Why would you get a hunting knife if you didn't feel threatened?
This is before they even broke down the door. This is he saw people walking outside, but that's the thing is that you're looking at the opposite effect. What did Mr. Parsons do? Okay, or what did the co-defendants do? Was it good to kick down a door? No, but that's a force element. Okay, was there an attempt to swing a knife? No. Did he actually stab him? No. So did he threaten? Okay, no. I mean, the testimony goes that basically they figured out it was the wrong guy. They started talking, and the one co-defendant goes, "Man, it's really, really good you're not Jose. We were going to stab him." Okay, and that's kind of the hinge of this threat of physical harm. Okay.
Counsel, you're at 4 minutes and 28 seconds. You want to reserve any
I'll
time?
reserve the remaining.
You want to reserve the remaining? Okay. And you'll have 15 minutes, obviously.
Thank you, Your Honor. Good morning again. May it please the Court, Assistant Prosecuting Attorney Daniela Bearden on behalf of the State of Ohio. In this appeal, there are 3 assignments of errors. First is the issue of hearsay, and then the other 2, the sufficiency argument and the manifest weight argument. Factually, this case involved the appellant, Anthony Parsons, and Nathaniel Worthy, and Toby Tackett. So these were the 3 men that were involved in the home invasion. The victim testified that he saw the appellant walking back and forth, pacing in front of his house, and that caused him concern because he did not know this man and didn't know why he was walking back and forth in front of his apartment. Soon after, he hears a knock on the door, and it's the appellant. He doesn't know this man, so he doesn't open it. At some point, he does grab a knife from his kitchen and sets it on the couch. He then hears another knock, and it's Nathaniel Worthy. Now, he did recognize Nathaniel Worthy from around town, and so he slightly opens up the door. He has the chain lock still on, so he wasn't inviting these men in, and as soon as he opens it, he's asking why they're there, and they're saying that they're looking for a man named Jose, they're demanding money. When the victim's trying to explain to him, hey, I'm not Jose, he sees an arm come across, so he's standing in close proximity to his door. He sees an arm come across, and the door is busted down on top of him. Well, not on top of him, but he had to back up to avoid being struck by the door. And then, so afterwards, they talk. At some point, Toby Tackett makes a statement saying, you were going to get stabbed if you were Jose. Jose owes us money. Eventually, the men do leave, and the victim is out and about at some point, and he sees the men still around in the area, which he thought was odd because after what had happened, he'd think that the guys would leave. He does talk to his neighbor. His neighbor does have concern, and so he contacts the police. And it was that same day. So the police responded within 2 hours to the victim's home and began to investigate. To clarify about the knife, so none of the 3 men actually brought out a knife while they were in the apartment based on the testimony. What had happened was once the police obtained descriptions of the 3 men, they went to downtown Elyria and began searching for them. During their pursuit of them, they saw one of the men that matched the description. It was Nathaniel Worthy. One of the officers saw him throw a knife in a bush, and that knife was subsequently recovered.
So what in the record, according to the state, supports the finding that harm was inflicted, threatened, or attempted to be inflicted?
Yes, Your Honor. So I would submit to the court that when they busted down the door, that was the infliction or attempt to inflict physical harm. So they're standing on one side of the door, they're talking to him through the small area where the chain lock, where the door is open, and they bust down the door. And whether or not actual harm was inflicted, it doesn't matter. It was the attempt, and it doesn't matter how great the harm is. Even the slightest amount of harm still qualifies. And that is from State v. Moore, which is a 9th District case. As to the threat to inflict physical harm, I would submit that when Toby Tackett said that the victim was going to get stabbed, that was a threat. And the fact that these men broke into his home, busted down his door, is also a threat. The officers testified that when they observed the victim, he was clearly shaken. He couldn't articulate his thoughts. He was chain smoking, and that based on their experience, that the victim was terrified. And while the victim was reluctant to pursue charges, the officers did say that this is common for victims of violent crimes because they're fearful of retaliation against, from the people for cooperating with the police. And again, although the victim did acknowledge that Toby Tackett was joking when he had made those statements, what the police officers described is that the victim did not think that this was a joke. He was terrified, he was scared, he was shaken. Going back to the claims for the hearsay, just to clarify, as far as whether or not the errors were properly preserved on the record, I would submit that they were not. During the first line of questioning that appellant points out, the officer is answering a question about who Elijah Nixon is and how he came to know who he was, essentially finding out the motive of the crime. He doesn't say where he learned this information from or who he learns the information from, just that he had learned it through the course of his investigation. The state then asks, and why is this important to you to know this information? And that is the point when defense counsel objected. So that's what the question that he was objecting to. And as the transcript goes on, again, defense counsel says he's objecting to the basis that he believed that the testimony being offered was the officer providing a legal conclusion. The objection was not based on hearsay. So that's why I argue that it was not properly preserved and should be reviewed for plain error.
Would just a objection with no grounds, in other words, if he didn't say legal conclusion, he just said objection, would your answer be different?
Your Honor, I would say that he did not object after or during the course of the officer's testimony as to what the officer was saying about Elijah Nixon. He didn't object until after the prosecutor completed her question, asking why the information was important to him. So I think that that takes it away from the hearsay. As to the second line of questioning, there's a line of questioning that the appellant points to. The first part, the officer testifies to a statement that Toby Tackett had made about wanting to clear his name, and then subsequently, while Toby was at the police station, the victim was there and stated, hey, that's the other guy that broke into my house, is essentially what he was saying. That was objected to, and it was as to what he said is what the attorney said. It's not clear which statement or both statements he was objecting to, because he just said as to what he said. And then subsequent to that, the court overruled it, and the officer continued to testify and testified about Toby being cooperative and so forth. After that, there was no objection to that testimony. Therefore, that was not properly preserved. As to the first line of questioning, the officer never offered an out-of-court statement. He never said that he had interviewed Nixon or provided any statements that Nixon had made. What he has said is what he had learned through the course of his investigation. He could have learned those statements from the defendant himself, which would have not been impermissible hearsay. Therefore, the appellant cannot ask this court to speculate that this testimony contained impermissible hearsay because the source of the information is not clear on the record. Regardless, even if it is considered hearsay pursuant to Rick's, it was statements offered into evidence to explain the officer's conduct during the course of his investigation. To be admissible, it must be relevant, equivocal, and contemporaneous. Also, the probative value must not be substantially outweighed by the danger of unfair prejudice, and the statements cannot connect the accused to the crime charged. And so that is exactly what the testimony offered by the officer was. He was explaining to the jury who this Elijah Nixon was, why he was important to the investigation, how they determined the motive of this crime. The value was not substantially outweighed by the danger of unfair prejudice. It only was provided about who Elijah Nixon was and why he was important to the investigation. And lastly, it did not connect the appellant to the crime. It connected Elijah Nixon to the crime, but in no way linked Parsons to the crime. The appellant was linked to the crime based on his own admissions to the officers that he was with Toby Tackett and Nathaniel Worthy, and the victim's testimony identifying him as one of the men that invaded his home. Therefore, there was no plain error. As to the second line of questioning, the state asked the officer who the officer spoke to, if anyone, and he was explaining that he spoke to Toby Tackett because Toby showed up and wanted to clear his name. This was not hearsay. This was offered to explain what the officer was doing in the course of his interview, who he interviewed, why he interviewed them. The statement made by the victim, hey, that's the other guy sitting out in the lobby at the police department. At that point, during, when they were at the police station, at that point when the victim had pointed out to the officer that that guy is one of the guys that invaded my home, Toby Tackett left the police station, but then subsequently came back and talked to the officer. That was the basis, that was the explanation that the officer was providing as far as what he was doing throughout his investigation. Lastly, the appellant claims that the trial court erred in allowing the officer to testify about Toby Tackett being cooperative. However, there were no out-of-court statements being made. The officer merely testified that Tackett was being cooperative with the police. So with that, unless there are any further questions, the state would ask that this court uphold the appellant's conviction for aggravated burglary.
All right, thank you very much. 4 minutes and 28 seconds for rebuttal.
Thank you. May it please the court on rebuttal. Foremost, on the hearsay issue. So at that time, okay, so objections to what he said, Your Honor, overruled. We continue. So at that time, Toby ended up leaving. Then he ended up coming back a short while later. And then I got to speak with Toby. He was extremely cooperative and fair and gave a great account of the whole ordeal. He basically matched DeAndre's story pretty much to a T, with maybe a nuance here or there. But it was a pretty consistent statement. There was an objection right there to saying, as to what he said. That is a list. That is essentially saying, well, yeah, one of the other guys, co-defendant said, yeah, I think it was pretty good at it. Officer conduct. He had said, yeah, I interviewed people. He didn't have to get into the substantive statements by a co-defendant. That wasn't, the state did not bring it as a witness. And just that goes. But then, when we go back to the sufficiency and the manifest weight, the state made the attempt that the kicking down the door was the infliction of physical harm or an attempt to inflict. That argument, Your Honor, they used the force. That definitely is sufficient for the element of the force to enter that house, undoubtedly. But there was no facts to show that the kicking of that door swinging in, that there was any intent that, you know what, we're going to knock this victim over, we're going to break his head open by kicking the door open. That was their use of force to get in the house. And sure, operative facts can mean multiple elements. I'm not arguing that. to the contrary, but when that door is kicked, there's nothing showing that the door was kicked because they knew or had knowledge or should have known that this guy got hit. He was going to get hit with the door. No facts show that this guy got hit with the door, or he was worried that he was going to get hit with the door. And this is sufficiency just on the separate element between an aggravated burglary and a burglary. Okay, is it the crime of the century? This is an Ocean's 12 or Ocean's 11. I mean, it went back to the house. But on that regard, that extra element, there is no objective facts to say that a threat was made by, until after this discussion, oh yeah, we were going to say, nothing before that there was any threat directed at him. And when the victim, I'm sure he was nervous, but that was the following day. So this happens on a Monday morning. This is when they're walking around the neighborhood the following day, that's when the neighbor calls the police.
Counsel, I haven't read the transcript yet, but it sounds almost like they didn't really believe he wasn't Jose since they came back. In other words, it's a good thing you're telling us you're not Jose because we're going to stab him. In other words, get your money together, get your act together.
Well, but there was no statements where, I mean, after, and this is the only witness we have as a victim, it's kind of like there's, oh, you're not Jose, that's good, okay, and then everyone's on their way. It's kind of bizarre. I mean, most of us would probably, somebody kicked my door and as soon as it left, I'm sure I'd phone the call, but, and he jumps back, I was nervous, I wasn't nervous. There's no weapon shown when that statement was made. So when the co-defendant's found with a box cutter, it's the following day when they're in that area. But then also, I think you have to look, it's an area with a lot of apartments, and these guys are from over here. That's how the officer knew some of them. Even the victim testified he knew them from around town, from Eli Square. So I would make that argument, Your Honor, to the court that both on a sufficiency and a manifest way, but that final element differentiating between F2 and F1, just there wasn't sufficient evidence. And I'm limiting the argument to that, but I'm not saying that there wasn't a burglary or there wasn't a criminal intent to go in the house. It's just attempt to inflict or burglary. Thank you.
All right, thank you both for presenting these arguments to the court today. We'll take the matter under advisement, issue a decision in due course. Clerk of courts will mail that decision to each of you on the day it's released, and the opinions are also posted on the Supreme Court of Ohio's website. Again, thank you for your arguments today.